Please continue to hold for the next available interpreter. Please continue to hold for the next available interpreter. Please hold for the next available.
Thank you for calling Underline Solutions. This is Karen, the language that you need?
Yes.
Thank you very much. Please hold a brief moment. I'm sorry just to inform you, unfortunately, our current interpreters are busy at the moment. By chance, does your customer speak any alternate language?
Is there an other language that you speak? No. No. No, I'm afraid not.
No worries. Now let me see what I can do for you. Please hold a brief moment while I get you a current interpreter.
All right, thank you.
Thank you.
Some days we get an interpreter right away. Some days it's a little bit more challenging. So just give them a few more minutes. Adjourning and I specifically ordered them in person. Yeah.
I have your interpreter on the line now.
Thank you.
Thank you.
Hi, this is Judge Sterkenburg at the 62B District Court. Before we proceed, I need to swear you in. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications? So help you God?
Yes.
Thank you. Thank you. I have defendant Mayet here who is being arraigned, and he understands about half of what I'm saying, but he doesn't understand the charge and the maximum penalty. So we're going to start there. So can you interpret the following?
Yeah.
The government says that on February 20th of this year, you operated a vehicle in the city of Kentwood. When you were intoxicated and had drank more than double the legal limit. Your blood alcohol content was more than 0.17 grams. That is a misdemeanor crime, punishable by up to 180 days in jail. You could also be fined up to $700. And there are other potential consequences like suspension of your license or community service. Do you understand the charge and the maximum penalties?
Yes, I do. Do I need to stay here?
Not yet. First,
I work night shift. I just started last night.
okay, I'm glad that you have a job, and we are not close to giving you a jail sentence yet. First, I need to advise you of your rights. After I advise you of your rights, I'll ask you if you want to plead guilty or not guilty. And only if you plead guilty or are found guilty by a jury will we talk about whether or not you have to do a jail sentence. Until then, you have the right to be presumed innocent. So let me go through your rights. First, you have the right to plead guilty or not guilty. Or you may stand mute. If you stand mute, a plea of not guilty will be entered for you.
But
You also have the right to plead no contest, but that requires permission of the court and is only done in special circumstances. You have the right to the assistance of an attorney. If you can't afford an attorney on your own, I'll give you a piece of paper that you can fill out, and it will ask questions to help me decide if you qualify for a court-appointed attorney. If the court appoints an attorney for you, you may have to repay some small part of that expense. And you have the right to a trial. You have the right to call witnesses to speak on your behalf and to question all witnesses against you. You may testify on your own behalf or remain silent without that silence being used against you. And you have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. As to the offense of operating a vehicle with a high BAC, sir, how do you plead? Guilty or not guilty? All right, if you plead guilty and the court accepts your guilty plea, you will give up all of the rights that I just read to you.
Yes.
And there will not be a trial of any kind. Is it your choice to waive those rights in order to enter your guilty plea?
Yeah, I had to play guilty because I was very drunk on that day.
All right, I have to ask you a few specific questions before I can accept your guilty plea. First, were you driving a car in the city of Kentwood on or around February 20th, 2021.
No, la kila ba kilo sita ne no so le la when they came away with ya. Yes.
Prior to driving the car, had you drank liquor or beer or some other substance that made you intoxicated?
Tu la no so le di ba tan ka ni ne no ti le bia la ka ma mu na tu bia.
Oh, your beer, no.
I drank beers.
And did that beer impair your ability to drive a car so that it resulted in an accident?
Quand on vit un côté bon et là, le manteau est pas là, est-ce que ça bien? Yes.
And the record here reflects that a data master breath test was conducted and it resulted in a 0.24 BAC.
Rất là có là bên này đó là quan vấn là ta thì có là đi qua là ta vừa là họ khi lùi bị thì nó.
So I do find a factual basis for your plea and will accept your guilty plea.
Không đó, từ khi bảo ta có là có là bị đau thì nó tự chủ là nó ta mà ổn nó.
The law requires that before I sentence you, I have you do an evaluation to learn about your history with alcohol.
Lớp ta là có tôi đến từ khi là sinh nhỏ như nào, trước đây là ta sinh nhỏ như là này, và em đó là các bạn lên thổ là ta mà đối với là các bạn tu nếu là tay các bạn ta đào tạo ông bộ tỷ nó. Yeah, no problem.
So, I haven't got to the counter. So I will have you go out to the counter as you leave the courthouse and get the information you need to schedule that evaluation.
Đó là mấy hàng đó là bảo khẩu cụ thể này là bằng kỹ là tạm nhá bằng quên nào đó là cái hình ảnh gì đang luôn. Bảo khá là bạn lệ tụi mình một kho tạm mà luôn bảo khá là ông một tí thanh này kỹ là tạm nhá nếu là cái hình ảnh này luôn. Yes.
They'll also give you a date to come back, and that is when I will impose the sentence.
Đó cái hình ảnh mình đó là các bạn hãy kỹ ra cái tông đó. Cả dân đi bắt đó. Bây giờ vấn đề tên là nào đó là các mà những bạn còn ba tháng thì bây giờ tên là hay là gì mà. Yes.
Do you have any questions for me?
Nên nó tí qua là một người à? No questions.
All right, I have one more question for you. I just want to clarify that you are choosing not to ask for a court-appointed attorney.
Nó đủ khi là bỏ lỡ rồi nó.
Yeah, khi bỏ lỡ tất cả là bỏ lỡ nó rồi.
I've never seen an attorney.
I know. We talked about your right to an attorney, and I told you I would give you this sheet to fill out if you wanted one. But you might have to pay back some of the cost.
Nên là với cái vấn đề của tôi là cái đó nó có phổ nó nên là khi đầu tiên bạn thằng này là phổ nó vì bạn chỉ để thực hiện được nên mình lưu vào.
Nên là đây là cái này một số đây cái việc của tôi là
So do you think which one is better?
Well, I can't give you that advice. That is your choice. You do not have to have an attorney. If you,
No,
go ahead, interpreter, thank you.
no, when you pick kuna pick on me, mama, kuna na tata kuda, na me teluga porona kini tilo na na tata mahu.
But if you ask for an attorney, we will have to come back for another date before we do the evaluation and sentencing.
Na me ano kina porona kini pabahai thodu aton blok, thodu aton blok tu bima na bale thod ki tama do do, loki ter do ma pangser de ni ta ki.
Yeah, right.
I don't know.
All right, here's what we will do. We will not appoint an attorney. We will not appoint an attorney at this time. But if you decide you want an attorney between now and your sentence, you can fill this out and return it to the court.
Yeah, perkembangan jadi, ada ternyata sudah kini orang yang bodoh ni mas, lagi orang kena ni beti orang. Ternyata sudah negara kalau kalau kita buat persoalan ni, sebab orang tu wajib bodoh sama macam tu ni, nanti boleh orang beti orang macam mana. Yes.
Okay, then we are all set for today. Thank you.
Thank you, man. Thank you. Do I need to go to the counter to get the information for the evaluation?
Yes.
Maybe, marking. Yes. Okay.
Okay, thank you.
Thank you.
Thank you, interpreter. I appreciate your assistance.
So I go.
Yes, you can go.
Thank you.
All right, Ms. Crow, Mr. Smith, Mr. Zendejas, and Mr. Floor. If you could come up, and two of you have seats on the benches and two of you have seats at the tables. You're all alleged to have committed the same offense. Who do I have? I'm missing one. Just, yeah, have a seat over here on this bench. Yeah. All right, who, Ms. Crow. It's alleged that on February 19th, 2021, you operated a vehicle in the city of Kentwood while your vehicle was suspended, revoked, or denied. All of you need to listen to the penalties. You may have heard them before. Driving with your license suspended, revoked, or denied is a misdemeanor. It is punishable by up to 93 days in jail, a fine of up to $500 plus court cost and collateral consequences like Secretary of State penalties. Ms. Crow, do you understand the charge and the maximum penalties?
I do understand.
All right, and you had the opportunity to hear the attorney discuss your rights. Are you asking the court to appoint an attorney to represent you in this matter?
Yes, please.
All right, I have to ask you some questions to determine whether or not you qualify. Do you currently receive any state benefits such as SNAP, Section 8, or Medicaid?
Yes, ma'am.
All right, then I can make a determination that you qualify for the assistance of an attorney at public expense. And I will appoint the Kent County Office of the Defender to represent you. Ma'am, is your address 1135 Jewston Street?
Correct.
And what is your phone number?
616-323-5948.
All right, ma'am, I will appoint the Kent County Office of the Defender to represent you. I'm going to give you some information on how to contact them. We're going to send your information to them. Counsel is going to recommend that you plead not guilty, and so I'm going to enter a not guilty plea for you today. On this matter, we'll schedule you for a date and time to return. My clerk will generate that notice for you if you just want to step out to the side, okay? Who is Mr. Smith? All right, Mr. Smith, do you understand the charge of driving with your license suspended, revoked, or denied?
Yes.
And do you understand the maximum penalties?
Yes.
All right, it is alleged that you committed this offense on February 11th, 2021. You heard the attorney discuss your rights with you. Is your license valid now?
Yes. And when that, they have court that they want to vote, so.
All right, but it does. It looks like your license is valid now. So here's what I'm going to do. I am not going to appoint a court-appointed attorney for you. I am going to enter a not guilty plea for you. I'm going to have you return for a pretrial with the city attorney. You can show her your valid license, okay? All right. My clerk will generate a notice for you if you just want to step off to the side. All right. Mr. Zendejas, that's you? All right. You can sit there, you can come up to the lectern however you want. You understand that the City of Kentwood alleges you operated a vehicle on February 18th, 2021 in the City of Kentwood while your driver's license was suspended, revoked, or denied. That is a misdemeanor punishable by up to 93 days in jail, a fine of $500, and collateral consequences. But you additionally, sir, are being alleged to have committed the misdemeanor offense of driving an unregistered vehicle, which is I want to make sure I tell you correctly. Which is punishable by up to 90 days in jail and a fine of $100. There's also a civil infraction listed here, which is a no insurance ticket. Sir, are you asking the court to appoint an attorney to represent you in this matter?
Yes, please.
All right, I have to ask you some questions to determine whether or not you qualify. First, are you currently accepting any state benefits such as Medicaid, SNAP, or Section 8?
Yes.
All right. What benefits do you receive?
Medicaid.
Okay. Then I can make a determination that you qualify for the assistance of a court-appointed attorney. Is your address 2034 Inwood?
Yes.
What is your phone number?
616-389-4855.
4855?
Yes.
All right. I'm going to give you some information on how you can contact the Kent County Office of the Defender and also send your information to them. We'll generate a notice for the next date and time for you to return. We'll enter a not guilty plea for you because that is what your counsel would advise you to do. Any questions for me?
No.
All right, I'm also going to give you a sheet of the things that you need to do to get your license current. That'll solve at least one of your problems, more than likely, okay? All right, there you go. You are welcome, Mr. Floor. Is that you?
My name is Gabriel Floor. I just want to make sure.
Oh, I'm saying floor, but it's four, F-O-O-R. I'm sorry. Do you ever see that where you read what you expect to see.
Absolutely.
So my apologies. I didn't mean to say it wrong.
Not the first time, though.
All right, sir. The city of Kentwood alleges that you committed the offense of driving with your license suspended, revoked, or denied on or around February 22nd, 2021. Do you understand the charge and the maximum penalties as you've heard several times? All right. Are you asking the court to appoint an attorney to represent you in this matter? All right, and as to the offense of driving with your license suspended, revoked, or denied, how do you plead?
Not guilty.
All right, we'll enter a not guilty plea for you. We'll schedule you for a time to come back and meet with the city attorney. I'm also going to give you a sheet that indicates how you can clear up your license. All right, that should be helpful to you. Do you have any questions for me?
I do, and I may be into with that form, but I did go to Secretary of State last week, and I tried to get any people that did say you could sync up with the court.
Yes, you have 2 unpaid tickets in the 58th District Court in Hudsonville, and you have 2 unpaid tickets in the 63rd District Court in Kent County. And the way those begin to affect your license is that you let them go into default, which means you don't pay them in the given time. And then the court is required to suspend your license. So you'll have a suspension on your license for each of those tickets from those courts, which is going to require you to 1, pay the fees that are part of the ticket, and then 2, pay the $45 clearance fee to remove the suspension. Okay. It should be helpful for you.
Yeah, thank you.
All right, my clerk will generate a notice. Please observe social distancing and just stand over to the side, and we'll get that for you.
Thank you.
You're welcome. Do I have Melet Malaku in here? Is that you, ma'am? All right. Ma'am, did you get an opportunity to go next door and hear the attorney discuss your rights? Okay. All right. You can come right on up to the lectern, ma'am. That's fine. All right. The city of Kentwood alleges that on February 17th, 2021, you committed the offense of violating the provisions of your temporary instruction permit. Ma'am, that is a misdemeanor. Punishable by up to 90 days in jail, a fine of $100 plus court costs. There's also a civil infraction here that you failed to yield right of way. Ma'am, do you understand the charge and the maximum penalties?
Yes, ma'am.
And you heard the attorney discuss your rights?
Yes, ma'am.
Are you asking the court to appoint an attorney to represent you in this matter? All right. As to the offense of violating the provisions of your temporary instruction permit, how do you plead? All right, not guilty, you said.
Not
Guilty
yes.
or not guilty? Okay, all right. Before I accept your guilty plea, ma'am, I have to ask you some questions. First, were you in fact driving a vehicle in the city of Kentwood, County of Kent on February 17th, 2021?
Yes.
All right, and at that time, did you have a temporary instruction permit?
Yes, I did.
And what did you do to violate the provisions of it?
Well, I was driving my vehicle without a 21-year-old license, so I would get charged for that.
Mhm.
I also got into a car accident trying to turn left, so that was my fault.
All right, well, I do believe that that establishes a sufficient factual basis to find you guilty. I will accept your plea. You don't have anything else on your license. Distractible, do you know? Jen, do you know if TIP violation is extractable off the top of your head?
I believe it does get reported.
Does. I was just double checking for your reference, ma'am. That is an offense that will get extracted to the Secretary of State. All right. So they're going to be aware of this conviction. And the penalties that they impose may include points on your license, etc. Okay. Some minor traffic offenses don't get abstracted, and there are a lot of them. And so I just always try to verify so you know what's coming. All right, is there anything that you would like the court to consider before I impose sentence?
Not much.
All right, I'm going to assess fines and costs in this matter. They total $240.
Is that for the misdemeanor alone?
That is for the misdemeanor alone. That's an excellent question. I was going to remind you that you also owe on the ticket, and that is $130.
I posted that last night, but it doesn't clear until 6 p.m. I said, so.
All right, and the person to ask about that is my cashier. I have two of them. You can ask Jackie or Letitia, and you're going to visit them on the way out to make payment or payment arrangements on this misdemeanor. But other than that, ma'am, you are all set. Thank you for your patience and your courtesy this morning. Sir, what is your name? Joe Johnson. Mr. Johnson, what are you here for?
I'm here for a city pay garnishment for my wages.
195252.
What time is it scheduled for? I'll write that. All right. No, I have it. I got a pretty thick docket today, so it took me a minute to find it. Appearing on my screen, is that Attorney McCarger? You'll have to unmute.
Yes, Your Honor, George McCarter, appearing on behalf of Delbert LaFonsi.
Well, and what matter are you here on?
This is, well, the parties are DNF Associates, LLC, which is the plaintiff, versus Delbert LaFonsi, LAFONTSEE, is the defendant. We filed a motion objecting to a garnishment and also a motion for an installment payment order. I can give you the case number if you need it.
I have it. I have it, sir. I just didn't have your name on it. So I needed to identify which matter you were here on.
Okay. And my client is here with me as well. Mr. LaFonsi.
Is he present with you in your office or also on Zoom?
He's on Zoom with me in my office.
Oh, and he also has the same name. Okay, all right, but I think I.
Yeah.
Yeah.
Yes, Your
Okay,
Honor.
there. Thank you. Yeah. No, we're not related.
That's fine. Let's see if I can find your file.
Well, that's Adam Burnham.
All right, is Delbert LaFonsi here?
Yes, Your Honor.
Okay, somebody might have
Your
to.
Honor.
I'm here for the plaintiff,
you-
Your Honor, on that case.
Who's here? Who is the defendant?
It's-
Defendant is Delbert LaFonsi, Your Honor.
Okay.
Plaintiff is Sterling Jewelers.
And I'm sorry for the confusion, Your Honor, but Mr. LaFonsi's name is listed as my name as well, George McCarter.
Right. So I'm sorry. I'm just trying to follow along here.
Right.
Okay. Well, let me ask you this. Do any of the parties in your matter need a breakout room to discuss settlement or any kind of pre-motion resolution?
I'd be happy to try that, Your Honor.
We can talk, Your Honor.
Yeah.
All right, then I can place you two gentlemen into a breakout room. I have a couple of arraignments yet that I need to finish. And so I will do those quickly while I place you into a breakout room. I don't know which McCarger to put in here. I'll invite you both, and then whoever is the appropriate person should go. All right, Mr. Oberholzer, do you represent Mr. McCoy?
I do, Your Honor. We are scheduled for sentencing at 11 a.m., Your Honor. I would appreciate an opportunity to go into a breakout room with Mr. McCoy before we do proceed on that, if the court would allow that.
Happy to do it.
Thank you, Your Honor.
You are welcome. I'm just going to make sure you are in the right place.
Looks like I'm still assigned to defender's office.
Like you can
Perfect.
jump right back there. Okay.
Thank you.
All right, the court is calling the case of the City of Kentwood versus Eric Manning, case number 21-50111OT. Mr. Manning, are you with us?
Yes, I am.
All right, the City of Kentwood alleges that on or around February 14th, 2021, you committed the offense of violating the provisions of your temporary instruction permit. That is a misdemeanor. It is punishable by up to 90 days in jail, a fine of $100 plus court cost. Do you understand the charge and the maximum penalties?
Yes, Your Honor.
And did you have an opportunity to hear Mr. Oberholzer discuss your rights?
Yes.
And are you asking the court to appoint an attorney to represent you in this matter?
No, I am not.
All right, as to the offense of violating the provisions of your temporary instruction permit, how do you plead?
Not guilty.
All right, we'll enter a not guilty plea for you, Mr. Manning. We will schedule a pretrial conference with the city attorney. You'll return on that date and time to proceed. And let's verify, is your address 559 Maryland Avenue?
Yes, it is.
All right, what is your phone number?
It is 616-821-5039.
All right, we're gonna get the date of your pretrial conference in the mail to you along with instructions on how to appear via Zoom.
Thank you.
You're welcome. And then the court is calling the case of the state of Michigan versus Justin Raby, case number 20-30301 ST. Mr. Raby? Go ahead and unmute yourself, sir.
Can you hear me?
I can now. All right, the state of Michigan alleges that on or around October 28th of 2020, you committed the offense of driving with your license suspended, revoked, or denied in the city of Kentwood, county of Kent. It's a misdemeanor punishable by up to 93 days in jail, a fine of $500 plus court costs and collateral consequences like Secretary of State penalties. Do you understand the charge and the maximum penalties?
Yes.
All right, and you had an opportunity to hear Mr. Overholzer discuss your rights.
Yes.
Wait a minute, wait. You're not here for arraignment.
No, yeah, I got a warrant I'm trying to clear up. I'm trying to pay the ticket and stuff. See if I can clear the warrant.
Well, let's see. Let me go through your file. You were here on November 10th of 2020. You requested and were denied a court-appointed attorney. You pled not guilty and you stated not responsible for the accompanying civil infraction. But then you were scheduled for a handful of dates and you did not appear at the date and time set for your jury trial. So that is how we set the warrant. Why didn't you show up?
Because it was a lot of confusing stuff because I had some cases with Grand Rapids too. So when I was calling and I was paying the stuff, I was asking them like, is this all that I gotta pay to get my license? And like, yeah. So I pay that ticket, but then this ticket pop up. You know, it's just been confusing me because I had other court dates. So I just was being confused with the courts like Kentwood and Grand Rapids.
It was confusing on December 7th and confusing on December 21st. And then confusing again on the date of your jury trial, which was January 13th. Confusing all those dates because you didn't appear for any of them. And we didn't issue a bench warrant for the first or second failure to appear.
Yeah, I'm not lying to you or nothing. I just was really confused. If you could see the other stuff, I've been going to court for that and paying and stuff. I didn't have money for the tickets. That's all that was.
I have a copy here of a schedule with all three of those dates that include your signature.
Okay.
How confusing could that be? Here's what we're gonna do. You're here now. We'll recall the warrant. I'm setting you for a pretrial date. And you can come back and meet with the state prosecutor and tell her about what the situation is with your license.
Okay, so how do I pay the ticket? Because that's like, I've been, you know what I'm saying? That's what I'm trying to do. I'm trying to pay these tickets so I can actually get my license. And I kept on paying all the tickets for the other courtroom. For the other courthouse, and they was telling me that that's all I needed to pay. Because I knew it was a ticket that I needed to pay for y'all. That was like $206, and I was calling and I was leaving messages on people's phone and asking them what was the actual amount of the ticket so I could pay it. And wasn't nobody calling me back. So I called the downtown courthouse and they ended up telling me a price that was the same that I owed them as the same that I owed y'all. So I thought that I was confused and it was actually downtown that I had court for. So I went and paid that. And then I received the letter.
Here is what we are going to do. We're going to set this for a pretrial conference. We're going to recall the warrant. I'm going to move you into a breakout room right now with my cashier. Her name is Jackie. She can tell you what specifically you owe to this court, okay? All right, is your address, sir, 1043 Baldwin Street, Southeast in the city of Grand Rapids?
Yes.
All right, is your phone number 419-3659? What's your phone number?
616-535-5611.
All right, because that notice, unless, do you have it generated now, Jennifer?
I do. It is for March 16th at 3:40.
March 16th, 3:40 in the afternoon. Write it down now. We'll also send you a notice in the mail so you know when and how to come back and communicate with the city attorney or the state.
March 16th? You said March 16th?
16th at 3:40 in the afternoon. All right, and Mr. Raby, I'm moving you right now into the cashier's breakout room, okay?
Okay.
Go ahead and watch your screen for that invitation. All right, who is appearing on my screen as Galaxy A11?
Brandon Newton. Can you hear me?
I can hear you.
It was for Brandon Newton. He had court at 9 a.m. this morning and we didn't know it was a Zoom meeting. So we just clicked on that when you were not busy, you would be able to speak with Brandon about his ticket.
Let's see. He's here for arraignment.
I just like to plead guilty, ma'am. Get this all out the way and get me a fine, whatever. Maybe set me up a payment plan. I'm still trying to get my license.
See. Give me a second.
Okay.
Mr. Newton, give me a second.
So I guess guilty for charge.
Well, I haven't asked you how you want to plead yet. Nobody's talked to you about your rights. So before you jump ahead.
Anyway. I'm pleading guilty anyway, ma'am. I'm going to pay you guys all your money. You're going to get your money.
Well, see, what I'm not sure that you might, what I think you might not understand, Mr. Newton, is that driving with your license suspended, revoked, or denied is actually a misdemeanor crime. And not only does it carry with it financial consequences, it carries with it Secretary of State consequences. When is the last time you had a valid license, sir?
The year 2000, but I still owe I think $2,900 for my reinstatement fee so I can get my license back. But I've been having
that doesn't sound like a reinstatement fee. That sounds like driver responsibility fees, which were abolished a couple of years ago. So the information that I have indicates that you have one unpaid ticket in the 57th District Court in Allegan, which is one suspension, and that is literally all you might need to do in order to clear up your license and obtain a license. So here's what I'm going to have you do. I'm going to have you speak to our MIDC attorney. All right, you can share with him some of this information. He'll go over your rights with you, and then you may come back, and if you still want to plead guilty at that time, you may do so, but you will do so with full knowledge of all of the consequences, okay? Mr. Oberholzer is meeting with another client at the moment, but when he returns, I'll place you into a breakout room with him.
Okay.
All right, and to everyone else who is patiently waiting, I'm going to recess for a moment, but I'll be back in 10.
So what?
You're waiting to speak with an attorney.
Guilty, shit. Fuck, guilty, whatever.
Something to do about Allegan. If you ever had a license, you got to pay a fine in Allegan, and then your license is cleared.
Can I leave now? Excuse me.
Mr. Raby, you may leave now.
Thank you.
Go to your
I
name.
unmuted, yeah.
Yeah, there you go.
Hey, Charlie Clapp, it's George McCarger. Can you hear me?
Hi, George. What's up?
Hey, Charlie, how you doing?
Good.
Hey, I hope I don't, this is maybe not the time to talk about this, but I left a couple messages for you.
Did you?
If I got a chance to talk to you about, her name was April.
Oh, yes. I've been talking to her, George.
Okay.
And directing traffic for her.
Yeah. Well, but she's trying to figure out, you see, I don't know if you remember, I referred her to you because I just know her.
You want me to move you into a breakout room?
Sure.
Yes.
In private? Okay. Give me 1 second.
Yeah, I shouldn't fuck around with this. Hey, Charlie.
Yeah.
I'll just give you a call. I'll just.
No problem, George.
All right.
Yeah.
Thanks.
Sorry, I just didn't want, there's people in the courtroom. I just didn't want things to be discussed. Are you good then, not going into a breakout room?
Yeah, we're all set.
Yeah, we don't need a breakout room. I'll just talk to Charlie later. Thank you.
Okay.
Right, Charlie? Good.
No problem.
Okay.
All right, Mr. Oberholzer,
Yes, Your Honor.
I have Mr. Newton here who I am going to, he's here to be arraigned. He was a little bit late and I'm going to place him in the breakout room with you so that you can advise him of his rights.
Great, thank you, Your Honor.
For your reference, as you speak to him, it's a DWLS charge. And I see only that he has no license and he has one ticket.
Great, thank you.
All right, you're welcome. Mr. Newton. Mr. Newton, if you can hear me, I've given you a breakout room invitation to meet with the attorney. Fantastic. All right. All right, the court is calling the case of DNF Associates versus Delbert LaFonci, case number 18-5649 GC. I did put the parties into a breakout room previously. Has there been any resolution in this matter?
Yes, good morning, Your Honor. Adam Berman appearing on behalf of the plaintiff, DNF Associates.
Good morning, Mr. Bergman.
The parties have entered into an agreement. We'd like to place the terms in the record so an order could be entered. We can perhaps get that order off to the garnishee employer so we can.
Right. Fantastic. Let's start with, hold on. I'm going to mute that background noise. Let's see. Here we go. Let's start with the appearance of counsel for the record.
Yes.
George McCarger, Your Honor, on behalf of the defendant, Mr. LaFonci, Delbert LaFonci.
All right, thank you. And then Mr. Bergman, you appear on behalf of DNF. Would you like to go ahead and read the terms of the resolution into the record?
Yes, Your Honor. The parties have agreed that plaintiff will receive $300 of garnished funds that are being held by the garnishee. The balance will be returned to the defendant. And further, the wage garnishment will be released. And then an installment payment order of $100 per month will begin May 28th, 2021.
May 28th, you said?
Yes.
All right.
And that should complete the terms, I believe, Mr. McCarter. If you have anything else to add?
Well, Your Honor, this Thursday, Mr. LaFonci's employer is, unless we get the order to them, today or tomorrow, they're going to take another garnishment. It's around $500 or $600. We also agree that if that happens, it will be, refunded or returned to Mr. LaFonci. Other than that, the only other, I guess, issue or item that I'd like to put on the record is the objection. One of the objections to the garnishment was based on the interest calculation. And as I understand it, the plaintiff has recalculated, and I'm not quite sure the date of the recalculation, but it's my understanding that, and we're agreeing to this, that the balance on the judgment is $6,610.40. Is that correct, Mr. Berman?
That is correct, as of today.
As of today, okay.
$6,610?
Correct.
And 40 cents, correct.
And 40 cents as of today.
Yes.
All right, well, gentlemen, here's what I will suggest to you. If you are able to compose those orders and get them to the court today, I'm happy to sign them. You each know how to contact Ms. Baker, my civil clerk, correct?
I do not on my end, but I can, Mr. Carter, I'm assuming, can get in contact with her to get those orders, correct?
I I will do my best. Yeah. I'm,
All right, well, here, I will, if you draft them and you send them, I'll give you the email addresses right now.
Thank you.
Yep, absolutely. It's Baker, B as in boy, A-K-E-R, P as in Patricia, at kentwood.us.
I got it, Your Honor. Thank you.
You are very welcome. Shoot those over to Patricia. She'll get them to me. I'll get them signed and we can get them back to you to make this as expedient as possible.
Thank you, Your Honor.
All right, you're welcome. Is there anything further on this matter?
No, Your Honor.
I'm pleased we can reach a resolution. Thank you so very much for your time and your patience this morning.
Thank you.
All right, Mr. Clapp, what matter are you here on?
Sorry, Your Honor. I am here for Stephanie Regaldo Godoy.
Is that Stephanie appearing on my screen just below? I have someone appearing on my screen as Stephanie.
Yes, that's me.
All right, good morning, Ms. Regaldo Godoy. Mr. Clapp, do you need to speak with your client before we proceed?
I do not believe so, Your Honor. Other than to verify that Ms. Regaldo Godoy received the pre-sentence report, which I sent back on February 23rd. Stephanie, did you get that?
I don't think so.
Oh, perhaps I should have a breakout then, if that's okay, Your Honor.
Okay, that's fantastic. And I will note that the court does have that and has reviewed it. So I will go ahead and set you two into a breakout room.
Thank you very much.
You're welcome. All right, do I have someone here on behalf of Citibank? No. Mr. Stanley, you appear on Babanampazi. Is that your client with you?
It is, Your Honor. Good to see you.
All right, fantastic. Thank you. And I did receive a pre-sentence investigative report in this matter. Did you as well?
Your Honor, I received the report. I had my client come in early so I could review it in its entirety with him. It's an important issue to him. When it's convenient to the court, we do have two relatively minor but important corrections.
Well, let's get the case called. I do have it. Let me grab my copy of that pre-sentence investigation report and recommendation. And then there's no need for an interpreter in this case, correct?
There is not.
Okay. All right, the court is calling the case of the state of Michigan versus Simeon Babanampazi, case number 19-30243 SM. Counsel, your appearance for the record.
May it please the Honorable Court, Attorney Frank Stanley on behalf of Mr. Babanampazi, who's here in the courtroom, here in my conference room on video to my right.
Good morning, Mr. Stanley and Mr. Babanampazi. This matter is scheduled for sentencing today. The court has in its possession a pre-sentence investigation report and recommendation, and I'm told that counsel has reviewed it with his client. What challenges, corrections, additions, or changes do you require, Mr. Stanley?
Your Honor, only on the cover sheet, if I may. The cover sheet indicates that my client did graduate from high school, which is correct, but it shows the year in 2017. Actually, he graduated with a Bachelor of Finance from American International University in 2017. He has his high school bachelor's degree as well as high school degree as well as a bachelor's degree in finance. He is also currently working on his master's degree. So the next paragraph, next line after that says last grade completed 16. He's actually has 22 years of formal education. So we're asking the 16 be corrected to 22 to correctly reflect the years of his education.
Thank you. And then for my personal edification, what was the high school graduation year date?
1992. In 1992, Your Honor.
Okay. And are those all of the corrections?
That is, Your Honor.
All right, then I'd be happy to hear your comments on behalf of your client before I impose sentence.
Your Honor, I realize the court assumed this from His Honor Judge Kelly, now retired. I'll try to be brief, but there is some significant history to my client here. My client is originally from Rwanda. He is here as a refugee. He was held as a prisoner of war in Rwanda for several months, experienced extreme torture, degradation, just all sorts of very bad things that were very hard on him. He was ultimately allowed to leave the country and came here as a refugee. He has no prior record outside of this. The court, in looking at the file, would note that the government actually moved for a motion to determine whether he was competent to stand trial. As a result of his political hardships in his native country, he suffered tremendously. He was found originally lacking in criminal capacity to assist in his defense. He was hospitalized for approximately 75 days. My client has no further contact with either of his children, which he deeply regrets, and he believes there was kind of a conspiracy against him by a church to take his children from him, to get them cell phones, so those cell phones could be used for assassins to track him down. These are some of the concerns that he's had in his life. But as far as Your Honor's case is concerned, this is a situation that was resolved with an agreement that he would enter a no contest plea under 769-4A to domestic violence. Count 1 was dismissed. The recommendation is for 8 months, which really rather surprised me. My client has been on medications. He is doing very well. This is a very old case. He is not really a danger to anybody in society at this point. And since he did basically 75 days of what is equivalent almost to incarceration, since he was mandatorily detained at a mental health facility, I think the court would be very well justified to simply give him fines and costs at this point. There might be a problem because 769-4A might actually require probation, but that could be, I just don't see a purpose for 8 months of probation. He's paid an awfully high price already for what's happened to him. I certainly trust the court's discretion and will accept whatever sentence the court gives, but I would ask that it be less than 8 months, and perhaps the court consider a non-reporting probation. And I would ask the court to file the recommendation for 769-4A diversion. Thank you, Your Honor.
Thank you, Mr. Stanley. I am glad that you brought that to my attention because it is a rather thick file and I wasn't necessarily familiar with your client's circumstances, although I did thoroughly review the report and recommendation, the interview and the history, as well as the background information. But confirm for me then, if there was a motion for competency, what was the outcome of that?
He was, after 75 days, a determination was made that he was now competent to stand trial. And we accepted that. The judge entered an order to that effect. Okay. And that's what led to the resolution of this case.
All right, fantastic. Because I don't necessarily see it in the top of the file here. Again, it's a lengthy file, and Judge Kelly had a different filing system than I do. So let me ask you this. One of the things I noted in the pre-sentence interview was that there had been some counseling that Mr. Bamamposi had been involved in. Is he currently engaged in any kind of counseling for trauma, for violence, for CBT, anything along those lines?
Your Honor, he is involved in counseling at Network
80?
Network 180.
Okay. All right. And that was alluded to, but the interviewer didn't seem to have any firm grasp on whether or not that was happening at this time.
My client, on information and belief, Your Honor, assures me that he is still in counseling with 180. He's spoken favorably about that agency. I know that would be a good agency. And I think he's actually appreciative of the help they are giving him.
Good, good. And so I'm certain that one of the purposes of the duration of probation as recommended would be to watch and monitor the continued and ongoing counseling of Mr. Babamposi. But also, as you touched upon, it is a requirement of deferral under 769-4A. And so it is the sentence of this court then that he serve a term of probation. I will make it a 6-month term because I'm compelled by your argument that he has paid already a steep price. Terms of the probation are as follows. He is not to violate the laws of any city, state, or federal government. He is not to leave the state without the court's permission. He is to make a truthful report to the probation officer monthly or as often as the probation officer requires. I will not object, Mr. Stanley, to non-reporting, and I will note that on here, but that is at the discretion of the probation officer. If they determine Mr. Babamposi is doing well, then certainly his need to report will be less frequent. You must notify the probation officer immediately of any change of address or employment status. You are to complete or continue counseling, pay whatever fee is required, and verify that with the probation officer. You are not to purchase or possess any firearms or ammunition or dangerous weapons. I didn't receive any kind of victim impact statement. And I recognize that the victim in this matter was Mr. Babamposi's son, who you report he has no contact with. Is that through ongoing CPS directives or?
Through the probate court, Your Honor. There is a pending case. He has separate counsel in that.
Okay.
Certainly not happy. He loves his children, would love to have contact with them, but he is complying with the probate court orders and working with his lawyer through that court. But he
so that is the active abuse and neglect case.
Yes.
All right. And so I will simply say that an additional term is to comply with all directives and or safety planning imposed by the probate court. And then I have to determine fines and costs. I do seem to recall there was an injury alleged in this. I don't believe I saw anything in terms of restitution being requested. Is that accurate, Mr. Stanley?
I don't think there's any reason for injuries. We have photographs and police reports. There's allegations of a bike, excuse me.
A bite
mark. Thank you. But there's no other damages or monetary compensation that would be justified, in my opinion.
Okay, I'm looking for my calculator here. I total fines and costs in this matter at $625. That is a final order of the court. Mr. Babamposi may seek appeal to the circuit court within 21 days. He may, of course, utilize your assistance, but if he would like the assistance of an attorney appointed at court expense, he must make that application within 14 days.
Your Honor, may I only ask to be sure I understand the court correctly? When the court says a final order, the court is granting a status as 769-4A. This is a
correct. Correct. If I didn't state that specifically, this is a sentence under 769-4A, but of course, appellate rights do attach at this point if you wanted to contest terms of the probationary sentence.
We understand that. Just want to make sure I understood the court was granting 769-4A.
Yes, and I am glad that you clarified. So we are all set.
Your Honor, thank you for the court's time.
Thank you for your patience this morning. I appreciate it. You and your client both have a wonderful day.
It's obvious the court is very busy and working hard. Thank you, Your Honor.
Thank you. All right. Let me ask one more time. Do I have anyone appearing on behalf of Citibank? Well.
Hello?
Hi, Mr. McCoy. I don't think you're appearing on behalf of Citibank.
Oh, I'm sorry. I'm sorry. I thought y'all was calling me.
No, but we will in just a moment. All right. Jen, can you have Patricia verify service, right? Yeah. Yes. Thank you. Sorry, Mr. Johnson. You'll have to wait a little bit longer. Absolutely. All right, the court is calling the case of the state of Michigan versus Stephanie Regaldo Godoy. This is case number 20-60307 FY. This matter is scheduled for sentencing this morning. Attorney Clapp appears on behalf of Ms. Regaldo Godoy, both appearing via Zoom. Mr. Clapp, good morning.
Good morning, Your Honor.
And you have had the opportunity to review this pre-sentence investigation report and recommendation with your client, correct?
I have, Your Honor.
Are there any changes, corrections, or additions that you would like to suggest?
No, Your Honor.
All right, give me one moment. I have my own copy that I reviewed.
No worries.
And I'll grab it. All right, Mr. Clapp, is there anything that you would like the court to consider before the court imposes sentence?
Yes, Your Honor, thank you. Ms. Regaldo Godoy is going to school at Success. My understanding is she's on probation as of January in Kentwood, Your Honor. That she was not on probation at the time of the offense. This offense happened in December, and I think she was placed on probation in January. And I asked the court to consider, rather than doing a weekend in jail, hold that over her head and sentence her straight probation. Thank you.
Thank you, Mr. Clapp. Let me verify that here in our system.
She's checking on it.
All right, well, somebody else is, and probably in probation, is in her file in our system.
Okay.
That is probation on a misdemeanor offense, it appears.
That's what she informs me of, Your Honor.
It was my clerk right behind me. Let's see. Well, what is the offense in that?
She pled to unlawful use of the motor vehicle. And the other stolen property at RNC was dismissed and drove while license expired was dismissed.
Your Honor, it looks like it's a retail fraud that she's currently on probation to you.
Yeah, that's what, yeah, I was I was just gonna say, I don't think that sounds right when my clerk indicated it to me. Right, yeah, I know, that's why I couldn't get into it. Okay, the bottom line is, I mean, they're both serious offenses, and I got the impression here that Miss Regaldo Godoy was in need of a significant wake-up call. But that being said, I don't know that dual terms of probation are necessary, nor do I think that they're productive or helpful. One serves the same as the other, but I would indicate to Ms. Regaldo Godoy that through your services, I'm sure, Mr. Clapp, what could have been a felony is now something that's remaining in the district court, and she should appreciate that for what it is. I will limit the sentence in this matter to fines and cost only, but I will be in contact with your probation officer. You have Ms. Kapersky to indicate that the recommendation here can and should be applied in your other case if there are any violations alleged of probation. Does that make sense, Ms. Regaldo Godoy?
Yes, Your Honor.
All right. Mr. Clapp, does that satisfy your ends as well?
Very much so, Your Honor. Thank you.
You're welcome. Then I will calculate fines and costs. All right, the total cost in this matter at $525. If you disagree with the court's decision, ma'am, you may make application for a court-appointed attorney within 14 days here. To appeal this to circuit court, appeal must be made within 21 days. I'm going to place your client, Mr. Clapp, and you may go with her if you would like, into a breakout room with the cashier now to make payment or payment arrangements.
Thank you, Honor.
You're welcome. All right, Mr. Oberholzer, are you with Mr. McCoy and Mr. Newton?
Yes, Your Honor. Mr. McCoy is scheduled for sentencing, and then Mr. Newton was here for arraignments here this morning.
Right, so we'll do those right now, but Patricia?
Joseph Jamal is now in the waiting room. He's from Singer and Singer.
Okay. And what did he say?
They didn't give her notice.
The court is calling the case of the City of Kentwood versus Brandon Scott Newton, case number 21-501140T. Mr. Newton, go ahead and unmute yourself. The City of Kentwood alleges that on February 15th, 2021, you operated a vehicle in the City of Kentwood, County of Kent, while your driver's license was suspended, revoked, or denied. That is a misdemeanor. It's punishable by up to 93 days in jail and a fine of $500 plus collateral consequences, such as Secretary of State penalties. Sir, do you understand the charge and the maximum penalties?
Yes.
All right, and you spoke with Mr. Oberholzer about your rights. One of your rights is the right to an attorney appointed at public expense if you can't afford one on your own. Are you asking the court to appoint an attorney to represent you in this matter?
Yes.
All right, I have to ask you some questions to determine whether or not you qualify for the assistance of a court-appointed attorney. Let's start with, are you currently accepting any state benefits such as Medicaid, SNAP, or Section 8?
No.
All right, where are you employed?
I work for a guy named Pat Waters. Work for a company called Top Quality Home Improvement. I build houses.
All right, what is your monthly gross wage before taxes?
Right now, because I ain't been getting many hours, everything going on. Right now, I'm averaging about maybe $2,000 a month, if that.
And what, how many people are in your family?
Right now, just me and one other. I really don't have much of a family, ma'am.
Well, does the other person in your family work outside of the home?
Yes, she works at Subway.
All right, I can't make a determination that you qualify at the moment for a court-appointed attorney, but if you believe that that should be revisited, you may feel free to come in and fill out the financial affidavit form, Mr. Newton.
Okay, I was just told plead not guilty so I can buy myself some time and work on paying on the editor fine. So hopefully I can get my license back and all is behind us.
Well, and you know, I understand the value to you in putting this behind you, but the way you do that is important. And that's why we have the MIDC attorney available and on tap so that you can seek his counsel. So that is for arraignment purposes. And if you are pleading not guilty, then I will enter a not guilty plea for you. We will set this matter up for a pretrial conference with the city attorney. Is your address 211 South Green Meadow?
No, no, it is. It used to be that. That's my old address. My new address is 158 Center Street, Green Meadows.
158.
Yep. Center.
Center Street.
Yep. Green Meadows.
Green Meadows is the name of the city.
It's a trailer park. Grand Rapids.
And that's 49548.
Correct.
All right, do you have a good phone number, sir?
Yep, 427-2806.
All right, we'll get a notice generated and sent out to you in the mail for your pretrial conference with the city attorney. I'm also going to send you a copy of this information that I told you I had as to how to clear up your license, okay?
Okay.
All right, you're all set for today, sir.
Okay, thank you.
You're welcome. The court is calling the case of the state of Michigan versus Joseph McCoy, case number 20-30133SM. Mr. McCoy, are you with us?
Yes, I am.
All right. Mr. McCoy appears with his attorney, Mr. Kurt Oberholzer. This matter is scheduled for... Mr. McCoy, are you outside?
Am I what?
Are you outside? There's a lot of like wind noise from your
I'm on the
location.
porch. I'm gonna head back in.
Could you go to someplace where there's a little less background noise?
Yeah, how about now?
That's much better. All right, this matter is scheduled for sentencing this morning. Your attorney, Mr. Oberholzer, is here. It's my understanding that you had the opportunity to discuss with him the pre-sentence investigation report. Mr. Oberholzer, do you have any corrections, additions, or challenges to that report?
Thank you very much. I did have a chance to review the pre-sentence investigation report on my own and together with Mr. McCoy, and we have no challenges, additions, or corrections to make at this time, Your Honor.
All right, thank you. Is there anything that you would like to share with the court before the court proceeds to sentence?
Absolutely. Thank you very much, Your Honor. But Your Honor, Mr. McCoy is certainly here before the court this morning, here to accept responsibility for his actions, Your Honor. I have had the pleasure of getting to know Mr. McCoy for several months, Your Honor. I actually represented Mr. McCoy in his case out of 63rd District Court. So we've had a chance to get to know each other. I will say that in my time working with Mr. McCoy, really, every time I met with him, he was actually in the Kent County Correctional Facility. But even despite being incarcerated, Mr. McCoy is very respectful. He was a pleasure to work with, Your Honor. And I know that he's, wanting to get this past him and move forward on a better note in his life altogether. I will say, though, Your Honor, in working with Mr. McCoy, reviewing the police reports, it seems to me that this was a very toxic relationship between Mr. McCoy and the victim in this matter. And I think both parties are better off going their separate ways. It's my understanding that that's what the plan is. They do share a child in common together, Josiah. And obviously they're going to work the best they can to provide the best possible life for Josiah, but they have no plans to get back together. I think both parties realize they're better off going their separate ways. So I think that's, a good decision on Mr. McCoy's part and the victim's part. But they both know that they need to do what's important for Josiah. And I'm hopeful that the parties will be able to work together and make sure that Josiah grows up in the best way possible. I'm happy to report, and as the pre-sentence investigation notes, Mr. McCoy, after being released from Kent County Correctional Facility, didn't waste any time. He did go out right away and secure a job through Van Andel Arena, working as a custodian. I know that Mr. McCoy reports to me he's disappointed with the hours that he is working. So he is actively working on looking for better jobs with more hours, more steady hours. And so he is actively looking for new employment, but he is working right now. And I think that's great, especially in this time of the Corona pandemic. The other thing I'd like to point out is he is also currently living with his younger sister right now. I know Mr. McCoy has great family support, and not only his sister, but his mother as well. They're both, trying to help him as much as possible, and making sure he stays on a good.
Wait, Mr. Overholzer, please stop. Mr. McCoy, I hear voices in the background, and I hear a lot of background just interference. I can't even hear your attorney.
Oh, I'm sorry. I was telling like my little cousin to like run off right quick because she was getting next to me while I was on the phone.
Yes, this is a court proceeding. Therefore, it is an extension of the courtroom, Mr. McCoy. We can't have little nephews up with you.
I'm sorry. I was kind of like shooing her away.
All right. Mr. Oberholzer, please proceed.
Thank you very much, Your Honor. Well, as I was saying, Your Honor, Mr. McCoy, he does have tremendous family support. He's surrounded by family, and I think it's a good thing helping him make sure that he, gets on a good path and stays on a good path here, Your Honor. I will say that his mother, Mr. McCoy's mother, has been acting as a third party between the victim in this matter and Mr. McCoy with regard to the care and exchange of the child, Josiah. So I know that, again, Mr. McCoy's mother has been a tremendous help and support with regard to that. So as I said before, though, the victim and Mr. McCoy, they have no plans on getting back together, Your Honor. Mr. McCoy has no objection if the court's to continue a no contact order. I think it seems like the parties are able to, again, arrange for the care and exchange of the child, Josiah, through Mr. McCoy's mother, and that has not been an issue at this time. Mr. McCoy does have, some past criminal history, Your Honor. We certainly acknowledge that. However, I don't think it's too late for Mr. McCoy to make changes in his life to ensure that he is never before a court again. And I'm hopeful that Mr. McCoy will, look at this as a learning experience and, make sure that he is not before a court again moving forward. I think if the court is to, have Mr. McCoy engage in things like counseling, I think that would be great, as the pre-sentence investigation report points out that he has never attended counseling before. And then Mr. McCoy and I also discussed, and I encourage Mr. McCoy to really pursue and finish getting his GED, Your Honor. And speaking with Mr. McCoy, he only has 2 classes to go in order to finish that and take his a GED test. And I think that would be a great thing for him to accomplish, and perhaps it would open some more doors for him moving forward, so that he can, continue to move forward in a positive manner, Your Honor. The pre-sentence investigation report does note, I believe, 21 days credited, Your Honor, for jail time while he was in the Kent County Correctional Facility. I would note, Your Honor, that after he did plead guilty to this charge on January 11, 2021, I do believe this court issued a personal recognizance bond. I would note that Mr. McCoy was not released just then. He was finishing up resolving his matter in the 61st District Court. And so I don't think he was officially released until February 8th, 2021. If my calculations are correct, that would be approximately 46 days that he served altogether on this charge. We would respectfully ask for the 46 days to be credited. However, if the court's not inclined to do so, we would certainly ask for the 21 days to be credited. And just so the court's aware, with regard to the 61st District Court case, that case has been completely resolved. To my understanding, I don't believe any probation was ordered. With that, Your Honor, we would respectfully ask the court, or leave the court, to sentence Mr. McCoy appropriately, Your Honor. We would just ask for the days to be credited in which he served in the Kent County Jail, and for any bond that was posted to be applied, although I do not believe there is any bond to be applied here, Your Honor. But we do thank the court for its time, and thank you very much, Your Honor.
Thank you, Mr. Oberholzer. Mr. McCoy, is there anything that you would like the court to take into consideration before the court imposes sentence?
Yes, I would like for you to know that, like I am just like, I'm on a different, like, I want to say level now, like in my life, where like I'm just bettering myself altogether, like I'm just at this point, man. I got a son. I just don't want to be back in that facility. Like, I don't want my son to be seeing me going to jail and stuff.
How old is Josiah?
He's 1 year old.
Yeah, he might not remember this, but give him a year, 2 years, he will remember. And so if this is a pattern for you, And I recognize this is not your first experience with being charged with the offense of domestic violence. If it becomes a consistent pattern for you in the future, he will notice it. He will see it. His opinions about women will be shaped by it.
Right.
And it will be a significant detriment to your son. So I'm glad of a couple of things. I'm glad your attorney advised me of what is happening in your 63rd District Court case, and that is that it is resolved. I'm glad that he indicated to me that you intend to, or he has encouraged you to pursue completion of your GED. I'm not going to give 46 days credit for time served, because if I release him on a PR bond, Mr. Overholzer, he doesn't get that credit. But Mr. McCoy, I want to believe very much that you're on a different path. I absolutely believe that people can make changes in their life that put them in the right direction and that keep them from being back here. And that is why we use probation. Probation is a tool. The idea is that at the end of probation, you will have more tools, be more productive, be stable, and be better positioned to be a productive member of society after you are done with the term of probation. And probation gets longer or shorter depending upon how well you do on it. And we want to see you succeed. So it is the sentence of this court that you will serve a term of probation for 14 months. You are not to violate the laws of any city, state, or federal government. You are not to leave the state without the court's permission. You are to make a truthful report to the probation officer monthly or more often as your probation officer may require. You are to notify your probation officer immediately of any change of address or employment status. You are not to possess or consume any alcohol or marijuana or other drugs unless prescribed by a physician. You are not to misuse prescription drugs. You are not to be in the presence of anyone using illegal drugs. You are to submit to alcohol and drug testing as directed by your probation officer. That requires a drug test fee of $30. You are to complete or continue counseling as directed by your probation officer. Pay whatever fee may be attendant to that and verify it with your probation officer. You are to have no contact with Leanna Hernandez in person, by phone, by email, by text, by social media, or by a third person other than your probation officer, or through your mother, who you are to use to facilitate parenting time, because I want you to have a strong relationship with your son.
Thank you.
You are not to possess or purchase any firearms or ammunition or dangerous weapons. You are to seek or maintain employment and verify with your probation officer. You are to enroll in a GED program. It is a term of your probation. I'm not going to require at this point that you complete it, because I can't guarantee what the world is going to look like in 6 months. I don't know what options are available to you because of COVID, but I want you to be in a program and verify that with your probation officer. Enroll. It will only help you. If you're disappointed in the hours and the position that you're in right now, the only way to improve it is through education and training. You are to serve. Yeah, I'm glad that's how you feel. You are to serve 21 days in jail with credit for 21 days served. But sir, I am adding an additional 60 days suspended. If you complete your probation successfully, no jail time. If I see you here because you picked up another domestic violence charge, that is what will happen.
Okay.
I am recommending to our probation department that you do a DV offender program. Now, the probation staff here is very good. They do their own internal screening. They are going to give you the referral for what is the most appropriate program for you. And I trust them to make sure that it will be a tool that is helpful to you. You will also pay fines and costs, which I'm going to total now. Fines and costs total $1,085. I'm going to place you in a breakout room at the conclusion of this hearing so that you may make payment or payment arrangements with my cashier. That is a final sentence of the court. If you disagree with this court's decision, you may appeal it to the circuit court within 21 days. If you would like the assistance of an attorney appointed at public expense, you must make application for that attorney within 21 days. We are all set. I wish you the best of luck, Mr. McCoy.
You too, man.
Thank you, Your Honor.
Thank you, Mr. Overholzer. I will see you this afternoon.
Thank you, Your Honor. And just very quickly, Your Honor, I would like to submit a motion to the court to withdraw from the previously called cases this morning for arraignments as a limited scope MIDC representative, Your Honor.
Motion granted. Thank you.
Thank you, Your Honor.
The court is calling the case of Citibank NA versus Joseph Johnson. This is case number 19-5252GC. Mr. Johnson, you can come to the lectern. I am going to, yep, you can stand right there. I'm going to set up our Polycom system so that everyone present via Zoom can see us. Mr. Jamal?
Yes, good morning, Your Honor. Joe Jamal on behalf of the plaintiff. I also want to apologize for late appearance. It doesn't look like we received notice of this hearing, or it's at least not in my records here, so I just want to notify the court as such, and I apologize.
Thank you. Yeah, I think that this was scheduled. What time was this scheduled, Nancy? Back at 10:30? Yeah. And Mr. Johnson has been waiting patiently since then. So I'm not sure what happened with the notice. Certainly it's something that I will look into.
I appreciate that. I will do the same.
This is defendant's objection to garnishment with notice of hearing. Defendant objects to a writ of garnishment issued on December 17th, 2020 because he has an installment payment order issued June 5th, 2019. Mr. Johnson, I see that you are unrepresented.
Yeah.
The way this works is that you filed this, and so I'll hear your argument. Then I will hear Mr. Jamal's argument and give you one last chance to rebut before I make my decision. So other than what is on this document, which I've reviewed, please tell me why you are objecting to this garnishment.
It's not so much, Your Honor, that I object to garnishment as, I mean, I've made the debt. I know that I owe the debt back. It's just when funds became somewhat unavailable and I stopped the payments, which was totally my fault, you know, and the garnishments came in. I was just looking in at where it said it would be at 25% of our pay, which would greatly kind of hurt my family, you know. So I was just thinking if we could come to something closer to the $265 a month that I was supposed to be paying.
All right, well, I'm going to review this. It looks like we have an order of judgment dated June 5th, 2019 in the amount of $6,177.95. June 2019. And income tax garnishment was requested on September 21st, 2019, but it does reflect, it appears that you were making payments through that date. Disclosure was filed. Another writ for garnishment of your income tax was requested September 8th, 2020. Which indicates continued payments. And then a wage garnishment was issued December 17th, 2020. The terms of the judgment state that the defendant shall pay the judgment in installment payments of $265 each month until the judgment is paid in full. The plaintiff shall not issue a periodic garnishment as long as payment is made. If defendant fails to make the required installment payments, plaintiff without notice or further order of this court may enforce this judgment by all means available under the Michigan court rules. All right, Mr. Jamal, your argument, please.
Yes, Your Honor. First and foremost, I'm more than willing to discuss a reasonable payment plan or to get Mr. Johnson back on track with the previous payment plan. It looks like payments were made through roughly December of 2019. Then we had some payments come back, so no payments have been really made since then, other than receipt of $55 from the initial state tax garnishment 2019. But like I mentioned, if Mr. Johnson would like to either get back on the $265 per month, we could do that, or if there's a number that if he's not able to do that, if there's a number he could do, more than willing to discuss.
I think it wasn't $265, it was $246, is that correct?
I thought it was 265. But
oh, it is $265. I pulled that other number right out of thin air. And so what I can do is I will place you gentlemen into a breakout room. This is streaming on YouTube right now because we allow public access to the court. So I will place the two of you in a breakout room. What that looks like, Mr. Jamal, is I'm going to send Mr. Johnson into our conference room where he'll use a laptop to communicate with you, which is where I will put your breakout room. And then once you've determined the details of the installment payment order, you can come back and place that on the record. Then your firm can submit an order, okay?
Okay.
All right, so let's move Mr. Jamal into conference room 4. Mr. Johnson, you are going to go out the courtroom, turn to your left, and then immediately to your left again into a conference room. There's a laptop on the table. Mr. Jamal should be there waiting to finish this conversation.
Thank you.
Thank you.